Okay, well, I've got 1 o'clock. We might start, and people can keep coming in as they arrive. For those of you who don't know, I'm Michelle Painter, one of the silks on the 9th floor Selborne Chambers and the general sort of editor of these lunchtime CPD series. Today's topic is a little bit different for us and a fascinating and very timely topic, particularly given the advances that I expect we've all made out of necessity as we've been forced to work from home during the course of the last 2 years and possibly into the future with COVID and post-COVID restrictions. The title of the topic tells you everything: paperless litigation in the post-COVID-19 era. We've got 2 speakers. Our first speaker is Giles Stapleton, who I understand is taking a measured view on the pros of paperless litigation. Giles came to the bar in about 2012, but he had a significant and lengthy prior career in banking, property and funds management, and that has very obviously influenced the pragmatic and commercial perspective that he brings to his litigation work. Giles has expertise in commercial corporations, property, equity, family law, and brings his specialist skill sets, including the skills derived in that earlier career, to his work in all of those matters. Now, our second speaker is Phillip Lonergan. He will discuss in quite some significant detail his approach and his experiences with paper litigation, and paper-free, I think, entirely is not the achievement and the goal of Phil's practice. Phil specialises in commercial litigation, particularly where it relates to financial services, competition and consumer law. He regularly appears in the Supreme Federal Courts as well as commissions of inquiry such as ICAC. And similarly, before he came to the bar and to us, Phil spent nearly 20 years prior to that in investment banking, both in Australia and abroad. He's got qualifications in economics and has undertaken postgraduate studies in something called quantitative finance. Must be fancy because I don't know what it is. Can I ask you to welcome both of our speakers, and in particular our first speaker, Giles Stapleton. Over to you, Giles.
Thanks, Michelle. I've been invited, I think, to provide a juxtaposition to the radical step by Phil Lonergan of trying to convert the whole bar into a totally paperless environment. And through our friendship, he's tried to coach me about how one might go entirely paperless. And I think he understands I may never quite give in. The fact is, the best way for me to sort of explain my position on all of this is to say that, firstly, my job is to be an advocate, and secondly, working with solicitors in a team. When barristers and solicitors work well together, the entire objective of the team is to be an advocate together. And what that means is to have effectively a desired effect on the listener, be it a client, be it a judge, be it a tribunal. And the question about how you go about that, in my view and experience, is a very personal thing. It's very much determined by the personality of the primary advocate, being the barrister at the bar table, but also very much a fact about the way in which the solicitor or firm of solicitors likes to practice too. So I think it is very much governed by a few things. It's governed by a little bit of the age of the person. Someone perhaps born in the early 70s may be less inclined to be a complete adopter, but somebody born in the early 90s may be more inclined to be very much a complete adopter of technology. So one has to ask how one feels one is most effective at being an advocate. Personally, for me, even though the court system is definitely going towards an entirely electronic approach, I still find it necessary for the purposes of being an advocate in communication by email, for example, to ensure that even if I'm typing a letter or an email on a computer, in order to make sure that it is as effective as possible, I will still print that email or that letter 1 to 3 times before it's sent. And the reason for that is I find that it is actually not as easy to identify gaps in, say, spaces or colons or commas or just grammar generally, and the nuance of the message electronically, unless you print it and you read the physical document. So I always make sure that with final submissions, final pleadings, final emails, that I print it, read it, edit it, and then print it again, and then edit it again and print it again. And the reason for that is I just find personally that eyesight and the cognitive connection between eyesight and mind is better served by looking at a physical document than looking at it only online. That extends to looking at folders and books. So textbooks, in my practice, I have as many textbooks as I can get. I appreciate that textbooks can be manipulated online through PDF by making notations of bookmarks in textbooks, and that is a wonderful facility. But personally, I still love having a textbook in my room with post-it notes and highlights that you can use and take to court. Similarly, with massive briefs, if you get a massive brief of even between 5 and 25 folders, I find it significantly easier to pick up a folder and literally flick through the 200 pages in the folder in order to see what's there. I find that I can see what's within the folder quicker by flicking it and then post-it noting various parts and then going back to them and highlighting them than I personally can by looking at a screen, flicking through a PDF, working out what's there. Because just from an eyesight point of view and the speed of my mind, it's much quicker looking at a physical document than it is looking at an electronic document. So my view is technology is absolutely an enabler of practice. It is absolutely brilliant in the way that one can store records of authorities and records of notes on authorities and interconnect those. But I still find it significantly easier to really be the most effective advocate I can be by having a physical folder and a physical book. Now, all of that means, I think that depending on the various personalities of solicitor and barrister working together in the modern environment that we're all in and respecting everybody in the way that we do, it's just about being an open, honest communicator about how you are best going to serve each other. And for me, if I get a large brief, I'm more than happy to accept it electronically. But even if that is what I get and I don't get a physical copy, I will still probably print the key documents like pleadings, affidavits, and work on them. So for me, technology is absolutely a wonderful enabler, but it's not going to be the entire way or the only way in which I practice, because I think possibly by being born in the 1970s, still need to hang on to some of that history and make sure I do it in my simple way and keep it simple and keep it efficient. So now you'll hear from Phil, unless you have any questions at this point, which I doubt.
Thanks, Giles. I have to let me just jump in here. Feel free, audience, to ask questions, either make yourself known on screen or feel free to use the chat function. I'm hoping that we'll have a little bit of time for questions at the end, but it's probably safest to send something through using the chat function. And that way, even if we don't get to it at the end, we'll be able to see what you've asked. And I'm sure between the joint efforts of our two speakers, we'll get you an answer. Just before we go to Phil, I have spent lockdown mostly in a tiny little study in Linfield, and I didn't think I would ever be able to go entirely paperless, and that's probably true, but I've done a pretty good run at it, including conducting some significant online appearances. So even people who were born somewhat before the 1970s, Giles, thank you for that, we are able to adapt and to cope. And here to tell us the best way to get onto that pathway, please welcome Phil Lonergan.
Thank you, Michelle. Thank you, Giles. And I am going to obviously go down the pathway of trying to convince everyone to go paperless. But as Giles said, I have tried to convince him, and well, he's still a work in progress. He's a slow adopter of technology, but we'll get him there eventually. The good thing is that he is using his computer and he is recognising the enabling and advantages of some aspects of the paperless practice. But one thing Giles did say, and we didn't talk about what he was going to say beforehand. I just said, don't tell me and I won't get upset. But one thing he did say that I completely agree with, it really is from the perspective of the bar, an engagement with the solicitor or solicitors about being part of a team in the presentation and the building of the case, so that how it's presented in court eventually is done in the best way. And I completely understand that a lot of people are, prefer paper, certainly when push comes to shove and, the dots matter and the commas matter. Some people are always going to be in that vein. However, that's not to say that we can't change. And I think the more we sit in front of computers, as Michelle just pointed out, COVID has forced a lot of people to adapt their practice and adapt it in ways that pre-COVID they just wouldn't have thought they would have done. But now I think a lot of people have realised that there are a lot of benefits that have come to the fore, and hopefully that continues a process of change within the legal industry, so that we are deriving a benefit of a less or lower carbon footprint. And more importantly, I think that we're better in the presentation of our cases in court. So, I mean, just dealing with the carbon footprint part of it, or being green, I'm not going to harp on about this. To me, it's a derivative benefit or collateral benefit of being paperless. It's certainly not the driver, but there is a benefit to it. And the Australian Legal Sector Alliance, they publish research every year in Australia. And in 2016, the legal industry in Australia consumed 111 kilos of paper per employee. 2018, that was 97 kilos per employee in the legal service industry. And in 2020, which is quite interesting, that dropped to just under 64 kilos, 63.97 kilos. So that's a massive drop between 2018 and 2020. A lot of that one would suspect is COVID related, or people changing their work practices as a result of COVID, working from home. And the last thing anyone wants to do when they're working from home is have trolley loads of paper sitting in their kitchen. As Giles, he's just gone offline with his photo or with his picture, but he did put his trolley in the background of his picture there in the office. But it's very different to have a couple of trolleys in your kitchen when you've got kids running around. Oh, there we are, there's the trolley. So anyway, 64 kilos of paper is 9,500 sheets of paper, which means across the industry in Australia, the legal services industry, we're consuming circa 2 billion sheets of paper a year, right? That is a lot of paper. But the good news is we're consuming a lot less, because one suspects that the 64 kilos versus the 97 has been a result of change in work behaviour, which has been, I guess, a catalyst or an effect from the COVID situation. Now, there are two objectives to me of being paperless. One, as I said, is this collateral benefit of being greener, having a lower carbon footprint, both in our professional lives and hopefully our personal lives. But I think more importantly, or certainly a necessary requirement to be paperless, is that it's got to be better. I mean, ultimately, that's what it's all about. Now, I've defined better as being both an increase in the efficiency of building and bringing together a case, and also the effectiveness in advocacy. Now, dealing with the first bit, increasing in efficiency, I would say that means largely an avoidance of duplication and effort, and secondly, an increase in the yield that we get through the team collaboration environment, a point that Giles was talking about, being part of a team with the solicitors and barrister. And the second part, the effectiveness in advocacy, is really about being more nimble and faster in the courtroom, and at least representing an outward persona of organisedness rather than organised chaos. So that's what I'm trying to sort of narrow myself down to today, but who knows where I'll end up. But the 3 areas of the litigation process that I'll quickly touch on, because I do want to give a bit of a demonstration, at least of how I deal with courtroom advocacy and preparation for it. So there are 3 areas of litigation. One loosely is referred to as discovery, or some people use the term e-discovery, which is not discovery in the legal term of it. It's just really sifting through a truckload of material that comes into the possession of the solicitor from the client, or an independent type of analysis of your respective hard drives and God knows what else, but to bring all the materials that are hopefully relevant to the case to the table. The second aspect of the litigation process is the case assessment and preparation stage. I can expand on that a little bit, but I won't spend too much time on it, because I want to talk mainly about the case presentation stage, which is the third stage. These 3 stages are not mutually exclusive by any stretch of the imagination, and I think particularly how you deal with the case assessment / preparation stage largely dictates how you present your case in court. You can't change boat halfway through the stream type of thing, or down the stream. Couple of terms that I'll refer to that some people might be familiar with, some people might not. Native format is really just how the evidence is created. Is it a document? Is it a JPEG? Is it a phone recording? You get the picture. Enhanced paper form is another term. Really what I'm talking about here is, invariably solicitors in particular, although counsels less so, but would do so if they had the choice, will present documents to their opposition by way of essentially photocopying the document and then scanning it, or scanning the document and then sending it off to the opposing side. That is essentially devoid of any metadata, and thus avoids potential unwanted discovery of information that might be embedded in the documents. But that requires then, obviously, if you're going to go into a paperless litigation type practice, to enhance that, i.e. to do what we call optical character recognition, or OCR, on the documents to enhance them so that they're in searchable format. And documents being able to be interrogated, i.e. searched and so forth, is a critical part of the ability to be paperless, I suggest, and a necessary aspect of the increase in efficiency that is derivable from being paperless. Metadata, that's just all the behind the scenes information that's embedded in documents. Fruitful, very fruitful potentially for litigation. It gives you all sorts of juicy information about when documents were created, who created them, and all sorts of things. So part of the process of interrogation, assessment, and e-discovery is about making sure you can see what is in metadata, or what the metadata is that's embedded in the relevant documents. So just quickly going to stage 1, which is this e-discovery stage. I mean, the ultimate goal is to sift through a multitude of material, and the amount of material that we're dealing with now as lawyers is just exponentially increasing. And the reason it's exponentially increasing, at least one of the reasons, is because nearly everything these days that we come across is generated electronically. Gone are the days where, well, maybe not totally gone, but largely gone are the days where people would write letters and post them with handwritten letter and post it to someone as a means of communication. We do that at Christmas time and so forth, but in terms of the business world, really most communications now are done on email. The documents are created in Word or PDF or something like that. Evidence usually comes off people's phones. It's WhatsApp messages, WeChat messages, Facebook conversations, email, instant message conversations, all that sort of stuff. They're the things now that we're required as lawyers to sift through to find the relevant material for the case. Contracts are usually done, whilst they might be signed in paper, usually the constructions of the contracts and the backs and forth between parties are all done via email or some equivalent to that. So e-discovery is largely now done by interrogating the electronic versions of so many different forms of documents, or not even documents, photos or conversations and the like. So metadata is a huge part of that, and the e-discovery process, or the, let's call it the sifting through materials to get what's relevant to the case, involves being able to, hopefully with reasonable speed, sift through that material. There are a couple of programs out in the market that do a decent job of that. In one case that I was involved in, or am involved in still, Everlaw is a product that does a very good job of that sort of thing. Provides great visibility of the metadata associated with documents, deals with multiple formats. You can deal with Word documents, text messages, all that sort of stuff, and is able then, once you've sifted through it all, to output it as largely, where amenable, which is nearly most things, into PDF documents or folders that then can be used for the purposes of briefing or for the solicitors, etc., to go into the next stage, which is the case preparation stage. Other vendors like Ringtail are very familiar in that space. Apparently, they've got a very good visual approach to document review and so forth. Nuix has got one as well. Interesting, Microsoft have just launched their own product called Microsoft 365 E5, which is a service that allows e-discovery within the subscriber group. So think of a company, you may have a large corporate, I don't know, think of a bank in the Banking Royal Commission. The amount of discovery that they had to go through of their own internal documents, emails, files, etc., would have been enormous. Microsoft E5 product now has been designed for companies who have subscription to do a whole e-discovery process on everything that's within their Microsoft environment. So I think that particular product is going to be very useful, at least in early stages of case sort of gathering of materials for solicitors to work with their clients to be able to quickly obtain a lot of information through an e-discovery process. Anyway, the bottom line that I want to get to before I move on to the next stage is most data or most evidence that we end up looking at is created electronically. And it just makes a lot of sense that if it's created electronically, that you're able to view it electronically and maintain the integrity of so much information, i.e. metadata, that's embedded in the relevant documents. So then moving on to the case assessment and preparation stage, really the two things that solicitors and barristers, for that matter, do at this stage. I mean, I'm being very high level here, so there may be many more things that people do, but the two things I think that are crucial, one is a chronology of events, and the second is a case proof, i.e. the analysis, laying out the causes of action, and then putting all of the relevant facts and so forth, in the for and against columns, and doing an assessment of the case. Then from there you can go then onto the composition of lay evidence and the and expert evidence as well. But here, and I think this is where a lot of change has happened over the sort of COVID era, if you like to call it that. Feels like an era, it's been going for a long time, is collaboration, right? The ability to collaborate is essential to the increase in efficiency, I think, in the preparation of a case. And the advantage, I think, or the catalyst that has occurred from COVID is that people now have realised that they don't need to be physically present with each other to collaborate. I mean, it wouldn't have been that long ago that to do a CPD event like this, we all would have been in person in a room at lunch, yourself on mute, hide your camera, and keep in your Ugg boots and not have to worry about it. But collaboration, I think there are two things that have evolved that are critical to being paperless and being more effective in being paperless than paper. One is file sharing, and the second is the concurrent editing of documents. Now, I don't think we can underestimate how advantageous things like Microsoft OneDrive, Teams, Dropbox, Google Drive, etc., have been in terms of our ability to collaborate virtually. Now, I use OneDrive a lot. The great thing with OneDrive is that I can have in the cloud a setup where I have n number of people that have access to all the documentation in that cloud, and I can sync that onto my hard drive on my computer, and anything that's changed by any person who has access is then synced to the cloud, and then from the cloud to my computer. So the addition, amendment, and withdrawal of documentations that are irrelevant is seamless now between parties who are all working together, because we can all collectively interact via the cloud file sharing server. And I mean, so Dropbox does it, Google does it. So there's an plethora of vendors that do this, but I think it's a huge advantage. And the other thing that it brings out is the concurrent editing of documents, i.e. people being able to literally, you could have 5 people sitting there looking at a Microsoft Word document, and all of you can edit that document at the same time and in real time see the other people editing that document. Now, pick a scenario like, I don't know, a solicitor is sitting there interviewing the plaintiff, the client. There's another solicitor who's sitting at home, who's on their laptop, who's taking notes and preparing the affidavit based on what the client's saying. There's a barrister sitting in his chambers who's also looking at the document, and you are all virtually able, or through virtualness, able to see that document being created, edited, comment. You can be on a Teams call or whatever at the same time. That, I think, is a huge advantage versus sitting around and having everyone with paper versions all potentially writing their own notes. And then there's somehow got to be then an assimilation of all that information into some central repository where people then can see what everyone else is doing and thinking about the particular documents. To me, that creates a huge amount of duplication of effort. And it's a time lag, because here we're dealing instantaneously almost with what people are doing, thinking about documents, versus paper where you're putting down your notes, etc. And then somehow then you've got to assimilate that back up so that other people can see it. So that's, I mean, to me, that's one of the big advantages of the paperless litigation process. The second part, look, when you create time chronologies and then you go and create your case proof, you are invariably doing that based on whatever documents have come into your possession in God only knows what format, and probably in a relatively disorganized way. It's very hard to start applying numbering systems to disparate documents. It's really only once we start putting together affidavits and exhibits and so forth that there's any numbering structures. But then, that may be a numbering structure within the document itself, but there's no relational numbering between all the different documents. I mean, as you'll see, 9 Selborne has put up a protocol that we'd like our solicitors to deal with in electronic briefing. Most of it really is about just giving us the files in some sort of organised way and giving us a URL or some sort of link, to the document. But I don't think that goes far enough. I mean, it is far enough in terms of just giving us the documents, but in terms of the preparation for the case, I think that there's a lot more that we need to do. And I'm going to skip now into the case presentation part of it, because really how we present a case, I think, is almost back solving for how we should prepare for the case. As I said, there's 2 pieces of information that or 2 work processes that we do. One is we prepare a chronology, and that's always invaluable. And 2, we do a case, case proof. And to me, those 2 document or 2 work pieces are essentially a lot of what I carry into the courtroom when I'm then arguing about a case. So case presentation is intrinsically related to how I prepare. So then turning to case presentation, the biggest pain in the butt, for lack of a better word, is what I call remapping, right? The scenario is not atypical at all, but solicitors, barristers all get their brief. Solicitor sends brief to barrister. Team of solicitors and barrister have been working on a bundle of documents, folders of documents for significant periods of time. Everyone's tagged the documents, everyone's marked it, highlighted it. They're yours. You are so familiar with how and where everything is in those few folders that you've got that you can almost do it by osmosis in terms of finding stuff. But then what happens is the court books get created, and creating court books is necessary, obviously, for the courts. But in terms of then how do you deal with all of this preparation that you've done? And you've got all your documents, you've got them all lined up how you like them, and then a court book's created which upends and creates a whole new numbering system that you then have to adapt everything that you've done for the previous 6 months, 12 months to deal with that, because the first thing the judge is going to look at is the court book, right? Because he hasn't had the history of all this. And all he wants to know about when he's talking about a particular point or asking a question, or you're asking a witness a question, what's the court book number? All right. So in the paper world, Giles, I think quite rightly, a lot of people, a lot of barristers like the familiarity of the paper because they have got their tags. And so when a barrister prepares to go to court, a lot of the time they'll get the court book, sometimes the night before. Hopefully we get it a few days before. But we'll literally take a bunch of files and pages out of their nicely highlighted and tagged folders, and then go and insert them into the court books and go and find the relevant pages in the court books and insert them so that they are turning the court book into as much as they can, excuse me, embedding their key documents into the court book, so then they can go to court and they are trying to transfer familiarity of what they've already done into the court books. And the solicitors invariably have to do the same, because at the end of the day, senior counsel turns around to junior counsel and says, where the hell is that? And junior counsel flicks through his notes and goes, I don't know, and turns around to the solicitor and goes, where is that document? And solicitors like, unfortunately, scrambling through trying to find where this relevant document is in the court book numbering. So part of teamwork here is that, hopefully an approach can be taken where that integration or remapping process is more seamless and more effective. And I'll get there, I promise. In improving so, or at least demonstrating how I think it should go. So other techniques that barristers use, they will literally take their own folders that they've got. They'll literally go and handwrite all of the court book numbers into the relevant pages of their folders, so that when they're talking or to the judge or asking questions, they at least have written down on the bottom of the page what the court book number is for the relevant document they want to take them to. Anyway, there's a multitude of processes, and some of them are very effective, and I've seen some excellent advocates. Obviously, history has had many excellent advocates who use paper, and hasn't had many who don't use paper. But that's a function of time, I would hope, and hopefully going forward, we do see excellence in advocacy from the paperless approach. Now, then the biggest problem with paperlessness, to be fair, is that when you're in the courtroom, you lack what I call real estate. The advantage of paper is that you can have, piles of paper here, piles of paper there, and you can turn around and you can find the piles of paper. So essentially the bar table becomes your real estate, as does the lectern. Unfortunately, with being paperless, the real estate that you've got doesn't extend to the entirety of the bar table, much to the benefit of the solicitors, I suspect. But it also means that the only real estate that you've got is the laptop and or iPad that's sitting in your possession on the lectern. So there's a significant decrease in the size of real estate that you have in terms of visualization of finding where you need to go. So that's the downside. But I will say I think there's a lot of upside. But instead of me going through that, just looking at the time, I'll just do a quick demonstration. So I'm just going to share my screen with you people so that you can at least see where I'm coming from a visual perspective. So what I'm going to do is take you all off that screen, put you there, and I'm going to share my screen now. No, I don't want that one. We'll share that one. Okay, so hopefully now what you're seeing is my screen. And considering this is about paperlessness, it'd be embarrassing if I... So this is what I call Court Master. Now, this is just something that I built myself, but I'm using this as a demonstration just to show you how I think. The case that we're going to look at here just quickly is something that the readers at the bar do as part of their mock trial for their bar practice course. So I've pre-configured this. So I'll just show you, I'll open this up so that you can see that. So the brief, just so you can see where I started. So typically one gets a brief. So this is a brief from the bar practice course, as I said. You've got all these
will actually do, and what could we do
outlay.
individually?
You've got observations. Someone needs to consult. Then you've got observation, defence counsel. There's a statement of claim. There's a defence. I'm not going to. You get the idea.
Two-page summary, or it's 2 or 3 page summary for each of those things. Give you a little bit more detail, but we don't really require to get everything. So this was really about giving you that.
That seems to have worked. Thanks, Phil.
No problems. Thank you, Michelle. So anyway, the point being that there's a brief, and it comes in, and what I'm going to do here is just show you. So this is like the data entry type thing. So the brief, if you just look across here to the right, I've put in the whole brief, but typically I'll break down the case into, the statement of claim, the defence. Here, there's an insurance contract. So just by way of a quick background, this particular case was about a shop owner who doubled his insurance coverage about a day or two before his entire shop burnt down. And the question, he was suing the insurer because the insurer wouldn't pay out the money because he said that the insurer said that the guy had burnt his shop down. So there's an insurance certificate, there's a couple of interviews, a couple of affidavits, and then there's an expert opinion. All right. So you'll see here that there's 10 files. These are the relevant documents. They're just the short names. If you come across to the main bit here, this is really where I'm doing what I call creating both the chronology and the case proof, if you like. So, here you've got a bunch of dates with events, nothing that every solicitor that's on this call hasn't seen before. At 8 o'clock in the morning on this particular date, Mr. Collins opened his shop. Here at 8 o'clock, he says that he locked up at 7:55 and went home. I mean, none of this is revolutionary. But what to me is important is that I can assign initials. So if I go over here, I define my people. Sergeant Starkey, Chris Collins, blah, blah, blah. So here I'm just assigning. So if you look at this particular point down here, you can see up here I've got Chris Collins and Kim Gustav, the relevant people. I'm defining a bunch of issues. So, my issues here, I've just put out a bunch of issues. What time he was in the shower was an extremely important piece of evidence in this case, or question of fact, I should say. There's the profitability of the business, there's an admission of guilt, whether the window was smashed or not. These are all relevant things. And so you'll see here, as I click in that, I can see my issues and so forth. So, but then I put up here, essentially what's my, like the shower. Let's take the shower. So Chris Collins, said he got home, he's about to fix dinner, he heard a call on the street. Then there was a prior inconsistent statement that he said he got home and had a shower, said he wasn't feeling well and went to bed, right? So obviously that's fertile ground for a cross-examination where you've got a prior inconsistent statement. So, the question about the shower becomes a relevant consideration that I want to address in the case. So anyway, the point is that you can put in your date, your time, your relevant fact, who it relates to, and then you'll see here the for and against columns, and I'll explain those in a second. By going back to the case courtmaster here. So what this is doing is, this is my, what I use in the courtroom. So I know that here, Chris Collins bought the business. So I'm just looking at this one here. 1st of the 8th, 2010. Chris Collins bought the business. Insurance was initially $90K. blah, 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 purchase equipment, etc., etc. So they're all relevant pieces of information, right? But if I'm sitting in the courtroom and something comes up about that, I want to be able to go to exactly where I drew that information from, because I would need to be able to address it to the judge straight away, all right? And so here I can literally, I just click on this, and what it's doing, you'll see here, it's brought up 2 files, and these 2 files are the 2 files. So file 5, page 2, and file 7, page 1, because they're the relevant pages that I have identified as being with these particular facts, right? So you'll see here, this is file 5, it's taking me to page 2, and this is file 7, and it's taking me to page 1, because that's where I want to go. Also, you'll see that I've pushed over here the court book volume and page numbers. So I know file 5, page 2 is volume 1, page 9, and file 7, page 1 is volume 1, page 14. So I don't need to address to the judge and say, oh, hang on, I've got to renumber this or whatever. And as you'll see, I'm dealing with here the file in my original format. I haven't gone and created the court book, or I have actually, but this is my own native files. And what I'm doing is I actually end up publishing down here the file numbers for every page in the court book that I have a file for. Just shut that down. I know I'm jumping around, I'm just conscious of time. Taking this example here, profitability of the business, this is a key issue. Chris Collins says that his takings were a lot of money, and they turned out there was a prior inconsistency that said that what he was saying was basically not true, or he changed his mind, I should say, and said it was like less than half. Now you'll see here a ton of files that I've made reference to, and there's a bunch of court book references. Now, imagine a scenario, I want to cross-examine Chris Collins about all of this. I can do that a number of ways, but one thing that I will do is here, if I click on this X mode and click on this, right, what this will do is it goes and creates a new PDF with all of the relevant pages or page ranges that I've identified here, and corresponding page numbers there for the court. So I call them bingo files. Don't ask me why, but you'll see here, file 5, page 2 to 3, I've got there, file 7. So I just create bookmarks for them all, so that I know now I can go through and have a chat to Chris on the stand, and I can say, right, okay, here are all my original files. I impose the court book numbering on them as well, and off I go. And so this has created a file, a new file with every page in my run sheet, so to speak, so that I can go and ask Chris Collins all about it. So file 9, page 2 to 3, and that's court book 1, page 24. Well, sorry, that's 9.6, it's court book 1, page 24. And I can see that because it's volume 1, page 24. So the advantage of all of this is that I am dealing with my files as I got them from my solicitor 6 months, 12 months ago. I've got it all in my native highlighting and so forth. And I am not having to go and impose them physically into court books or anything like that, because I can literally, if I just show you again here on the data tab, all I'm doing is creating, this is all I'm doing. Like, so you can ignore the unique numbers, but I'm saying, okay, court book volume 1, I want to start with file 2 being here, statement of claim, then file 3, then file 5, file 6, blah, 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 file 4, I took it out of order. If I wanted, I could take respective pages as opposed to the whole files. I could start at a new page, etc., etc. But you know, the bottom line of all of this is that I'm able to, in a virtual manner, take whatever documentation I've got that's relevant to the case, and when I get my court book numbering from the other side or from my own solicitor, I'm very quickly able to then go and literally map what my files are to the court book numbering or to the court book sequence, and create a virtual court book using my own existing files. And I mean, for me, I find that extremely valuable. It also is valuable because here, if I so chose, and I wanted to search for, I don't know, insurance, I can type insurance there, text search in my X mode. I click on this, and what you'll see here is it's gone and created the PDF with all the documents, but it's telling me on every page where the word insurance pops up. So page 1, word 192, so of 283, tells me the file reference, also from what file this page has been extracted. So I'm very quickly able to, and it tells me the 20 words before, the 20 words after, so that instead of looking through all this, I'm able to quite quickly search my keyword, insurance, scan through there, and it's like, okay, right, I want to go to this one. And then I know, okay, well, it's page 3, word 364. So I can go to the page 3, and it's down here somewhere, right, about insurance. And so I know that that's the bit of information that I want to go to and take the court to. And it's much faster because I'm able to interrogate the documents for that word, which I just couldn't do with paper, because I would have to, in my head or through some sort of highlighting or tabbing structure, go to find that particular word. So that sort of stuff's extremely, to me, invaluable when you're sitting in court and someone says something that's unexpected and you're like, hang on, there's a contrapoint to that, or there's somewhere where that's completely inconsistent and I need to go and find it quickly. I need to be able to go through and use a keyword search to find that, because then I can attack, hopefully in cross-examination, that person around that point. And if I'm able to do that in real time, then I can do that while I'm standing on my feet in cross-examination, potentially. Not so easy when you're standing in front of a judge and saying, hold on, I'm just going to do a keyword search. They look at you like you're from Mars half the time. But, versus if you were looking through some paper, they'd be like, oh, okay, I understand that. Anyway, so I'm going to summarize now, because I do think we are shortly out of time. There is, sorry, I'll just stop my sharing so we can come back to me. There is, this was a very quick demonstration of at least how I deal with case preparation and presentation somewhat in the courtroom. I don't feel the need 90% of the time to deal with paper. Sometimes, there are bits of paper that you might want to tender and so forth. But I find personally that my ability to maintain the integrity of how I create and prepare for my case through to the presentation of my case, very efficient in terms of not duplication of time and effort, at least on my part. And I also find that my ability to be fluid on my feet in the courtroom, enhanced by the having at my fingertips the ability to interrogate a lot of documents in very quick order to find key bits of information. but it requires a level of organisation, and really the remapping process, I think, is critical to that. I completely accept what Giles said at the start, which is that, it's horses for courses. Much easier to deal with this if you've been a native Gen Z or millennial than it is if you've been a Gen X, an older iteration of Gen X, or a baby boomer. So, horses for courses, but, as Michelle pointed out, we all can adapt. And I do think that going forward, at least if you're not going completely paperless, the point at which you start printing out paper is later in the process. Back to you, Michelle. Thank you. Michelle?
Sorry, I was struggling with the technology. Not a very good endorsement for me. Thank you, Phil. That's fascinating. I've come across some of that sort of technology in the context of a really significant trial I did earlier in the year. And we had about a 35,000-page court book, which we had in paper over about 50 different lever arch folders. But we also had it electronically. And most of us started out the 6-week trial with a funny amalgam of paper and a bit of electronic. But I think by the end, we were all, especially my team, we'd started largely electronic, but I think everybody in the room was largely electronic by the time we finished. Because of that search function, you just can't underestimate how powerful those search functions are, particularly when you and your junior or you and your colleague are aware of what's in the material and are able to conduct those searches very quickly. But thank you, Phil, and thank you, Giles. It certainly is the way of the future, I think. And I guess the extent to which we work with a mix of the two is largely personality driven, but perhaps matter driven. So smaller matters are easier to do one way or the other. But I think larger matters are increasingly more and more electronic based. Now, does anyone have any questions? I haven't seen anything come through on the chat functions, but if you, I don't know, you can do a little wave if you want to ask something. If not, I'll just give you a moment to make yourself known. I don't see anything. I'm scanning my screens. Well, look, thank you very much. Thank you all for attending. We do appreciate seeing, if not your faces, then at least your names up there and knowing that we're not just howling into the wind. We try to run these sorts of lunchtime sessions. They were born out of COVID, but we think we're going to probably keep it up into a post-COVID environment. I think because it gives you the opportunity to come and get some CPD from us where you couldn't do that if you had to come in person. So thank you all for attending. I hope that we see you on the next one we do, which will probably, given that it's almost the end of October, probably be during the first term in 2022. So we'll send some invitations around, but that's good timing for you ahead of getting your practicing certificates renewed in March, April. Same for us. So again, thanks, thank you, and please join me in thanking our two terrific speakers. See you all next time. Bye.
Thanks, Michelle.